So it's my pleasure to welcome everybody to this joint meeting of the Edinburgh Roman Law Group and the St Andrews Institute for Constitutional and Legal Research. And we're fortunate today to be able to invite Dr Lisa Eberle to our meeting to give a paper on the Praetors Edict in its political context. The title of the paper is The Edicts of the Praetors, Law, Politics and Revolution in Ancient Rome. Dr Eberle is the Assistant Professor in Ancient History at University of Tübingen. She formerly was a Junior Research Fellow at St Hilda's College, Oxford, and she completed her thesis at the University of California, Berkeley, where she wrote about provincial administration. So without further ado, I will hand over to Dr Eberle to give her paper on the political context of the Praetorian Edict. Thank you, Dr Eberle.
Really also just have at it. Excellent. All right. So with that being said, let me begin properly. All right. In 74 BCE, Gaius Varus, an aspiring member of Rome's office-holding elite, secured an important step in his political career. After various appointments and the staffs of other magistrates, he now obtained an important magistracy himself. In the spring of 74, Gaius Varus was elected praetor urbanus. Now, as many of you will know, the urban praetor was the major magistrate in Rome, and holders of the office were expected to publish an edict in which they laid out the legal remedies that they would grant during their year of tenure. Varus did not disappoint, right? As praetor-elect, the composition of his edict seems to have been his main preoccupation. Its clauses were the subject of negotiation between him and various potentially affected parties. In fact, as Cicero would have it, Varus organized a veritable marketplace, nundinae, for legal remedies, in which the highest bidder would have his or her way. Varus' edictum marketplace is the most elaborate and detailed account of how a praetor urbanus composed his edict that we have preserved. Curiously enough, then, it would seem to contradict the ways in which the history of the urban praetor's edict, or the Praetorian Edict, as it is often told, is told in textbooks and introductions to Roman law. Students of Roman law and history learned that during the last 2 centuries BCE, when the edict constituted a major arena for legal innovation in ancient Rome, its composition was firmly in the hands of jurists and other specialists, who took care to keep its text stable and to make additions as they saw fit. Of course, the seeming contradiction between Varus's edictal marketplace and the story that Romanists tell about the edict might readily be explained with reference to the kind of source from which we know about Varus's doing, and that's a courtroom speech by Cicero that was part of Varus's prosecution for corruption. Now, in this speech, the edictal marketplace was one among many vignettes designed to make Varus look bad, to make him look venal and greedy, to show how due to this venality and due to this greed, his behavior deviated from the norm. And yet, one might reasonably ask just what aspect of how Varus composed his edict would have scandalized Cicero's audience. His supposed sale of legal remedies? I would imagine, yes. His alleged conversations with potentially affected parties? Who knows? Or his ostensible involvement in the composition of his own edict? Yes, like, is this Cicero's point? Is like, oh my God, Varus, he meddled in his own edict, and that's only people who get paid to do that, essentially do that. In this paper, I'll suggest that the members of Rome's political elite, contrary to established opinion, were often involved in putting together the judicial edicts that their magistracies required. While no such edict is preserved, we do have sparse, but I think heretofore largely neglected evidence for how these things were actually composed, what happened in the process of composition. Now, based on this evidence, I contend the Edict of the Praetors would appear to be a more fitting description of the legal practice than the Praetorian Edict. For the content of these edicts could and did vary from year to year, so I'll argue, depending on the preferences of the respective magistrates, on the ways in which they responded to different interest groups that put pressure on them, and indeed on their attitudes to legal expertise and how they chose to make use of it. The rhetoric of judicial edicts was not empty either, I'll suggest. They're presented as the speech of a magistrate. They presented as the speech of a magistrate, and contemporaries clearly associated their content with the magistrates that issued them, at times with fatal consequences. As a result, these edicts should not be cordoned off into the histories of legal doctrine and jurisprudential expertise. Instead, I think they were a vital but neglected part of Roman political culture during the last 2 centuries of the Roman Republic and beyond. And yet these edicts, I think, do not appear to lack interest from a legal perspective. The edicts of the praetors, so suggest, embodied a way of doing law that could encompass revolution. And so my argument here will proceed in 3 parts. Firstly, I critically examine some of the arguments that scholars have used to suggest that notwithstanding these edicts rhetoric, that in the hand of legal and memory specialists. Second, I turn to a set of passages from Cicero's letters, which concern the making of judicial edicts in Rome's Republican provinces. Based on these passages, we can begin to outline some of the factors that informed how Cicero and other magistrates like him composed their edicts. In a third and final section, I then focus on judicial edicts in the city itself, where historiographical accounts of death crises and the roles that praetors and their edicts played in them suggest that analogous dynamics most likely were also at work there. A brief reflection on the relationship between law, politics, and revolution in ancient Rome then concludes the paper. So part 1, and I'll just start with some sort of things that many of you will just know, but it seemed useful to outline them anyways. The English term edict derives from a Latin edictum, and this was the term that Romans used to refer to the pronouncement of magistrates. Edicere, the word from which this term derives, singled out a particular type of speech, the speech in which the members of Rome's political elite engage as office holders. At least by their name, then, judicial edicts were intimately tied to the magistrates who published them. They were understood to be their speech. The fact that these edicts repeatedly used verbs in the first person singular further contributes to that impression. More particularly, these verbs also were in the future tense. Examples include "ubebo," "I'll order," "dabo," "I'll give," "kogam," "I'll force." In other words, judicial edicts presented as the pronouncements of magistrates about what they were going to do during their year of office. These pronouncements were also written up and displayed publicly in the city of Rome and in the provinces. The language used to describe judicial edicts would suggest that this public written up form was the main form in which contemporaries engaged with them. They were written up in black letters on wooden boards that were painted in white. Section headings were written in red. Correspondingly, album, or whiteboard, was another way to refer to a judicial edict, and the subsections of these texts were known as rubricae, or red letters. Even jurists use this terminology at times, and I give you some examples from the handout. Most of the pronouncements that we have preserved in the writings of later jurists, right, most provisions of the edict that we have preserved in the writings of later jurists, set out very precisely the rules according to which the magistrates in question promised to behave. But some of these promises also seem more general. Consider the following: whatever anyone under the age of 25 is alleged to have done, I'll pay attention to it. Animad vertam. The vaguenesses of promises such as these has led Walter Zell to posit that judicial edicts originated as election programs in which the magistrates in question announced the areas and issues to which they would attend during their year of office. While I'm not sure that this conclusion of Zell necessarily follows, I think some things about some aspects of Roman political culture would contradict this, but we'll see. His suggestion that such promises would seem to belong to a rechtspolitisches Programm, a legal political program of sorts, to me at least seems spot on. In fact, I would suggest that judicial edicts can be understood as programs of sorts. Each edict presented as the pronouncement of a magistrate about what he was going to do during his year of office. Now, again, as many of you know, none of this is new. The facts I've outlined so far can be found in textbooks and introductions to Roman law. Some of their authors even follow my interpretation of them. So, for instance, in his 2-volume outline of Roman legal history, Franz Wiecker wrote that by its very name, by its very nature, pardon me, seines Wesens nach, the annual edict of the praetor was a program. 2 pages later, however, Wiecker goes to great lengths to explain that despite this nature, despite this programmatic nature, no Roman praetor ever treated his edict as a program. According to him, each praetor took over the edict of his predecessor. This was simply a technical necessity, he claimed, because Roman magistrates simply lacked the time and expertise to compose their own edicts. Instead, Wiecker imagines a closed and continuous group of jurists and/or scribae who controlled the text of the praetor's edict. kept it stable, and made improvements as necessary. Well, Viaka outlines a set of considerations to substantiate this view, and I'll sort of return and discuss some of these considerations at later stages in this presentation. It should also be pointed out that scholars do not seem to have found direct evidence for the involvement of either scribi or jurists in the composition of judicial edicts. Now, scribi first, in his 2020 Cultural and Social History of Roman Scribi, Benjamin Hartmann fails to mention their involvement in the composition of judicial edicts. And I think this is no accident. As Hartmann explains in fascinating detail, scribi were indeed the keepers of public writing in Rome, but in its archival and non-published forms. Their work, their persons were constantly associated with wax tablets and with incising, and not with whiteboards and painting, the materialities with which judicial edicts seem to have been intertwined. To be sure, at least one scriba, we know, proudly advertised his legal learning. And he will not have been the only one that was able to claim such skills. This is a nice gravestone from Rome. And indeed, I think scriba might have made copies of judicial edicts. They might have provided such copies to incoming magistrates. They might have advised these magistrates on what to include in their own edicts. We simply cannot rule out any of these possibilities. And I think on the face of it, all of this seems really, really likely. However, I think nothing in our evidence would really support the very strong view that scriba were somehow in control of the praetors' edict and their content. And I think an analogous, possibly even stronger case can be made in relation to Roman jurists and their involvement in the edict's composition. The suggestion that jurists steered the history of the Praetorian edict goes back at least to the 19th century, where it seems to have been supported in two ways. One, the first argumentative strategy seems to have been the idea that traces of the praetors' edict that we have preserved cannot have been composed, but with the help of jurists. And the second argumentative strategy seems to be the idea that the praetor urbanus had a concilium, a formal group of advisors, that some of these advisors were jurists, and that these jurists were involved in the composition of the edict. The first idea, the idea that the traces of the praetors' edict that we have preserved cannot have been composed, but with the help of jurists, seems to be, at least to me, a mere judgment call, right? Making it, for me, just makes it hard to critically engage with it. One might, however, note that this view seems to be built on debatable assumptions. Among other things, it appears to rely on the idea that legal expertise in ancient Rome was very limited to a very small group of trained specialists. Which I think is a view that recently people like Jill Harris, or also Christine-Lena Steinthaler in her 2019 monograph have sort of called into question. By contrast, the second position, sort of all these arguments about the concilium, actually has recourse to some evidence. And it's basically three passages from Cicero's writing, one from his defense of Lucius Valerius Flaccus against corruption charges during his governorship of Asia, and two from the Oratore. And so while the first passage from the Pro Flacco shows that Flaccus, as governor of the province of Asia, did indeed have a concilium, the one member of it whom we know, Gaius Apuleius Decianus, is not known to have laid claim to having any particular legal expertise. The two passages from the Oratore describe how men known for the legal expertise, as Quintus Mucius Scabula and Gaius Licinius Crassus, were in attendance during trials before the praetor Urbanus. Admittedly, Crassus is described as sitting on the praetor's bench, which suggests a close and privileged relationship between him and the praetor. But the two passages do not mention a concilium, and really they do not show how these legal experts gave any advice to the respective praetors either. Again, fourth passage that seems relevant in this context, in the Topica, Cicero does claim that in relation to important private suits, jurists were often invited to be member of concilia. Now, whether these were the concilia, the advisory boards of the judicial magistrate or the judge whom he appointed is not unclear, but there we go. Some jurists sit on concilia in the city of Rome. Okay. Crucially, I think, none of these passages show how incoming praetors consulted the jurists as they were composing their edict. Again, we cannot exclude this possibility that such consultation existed. And again, I think that they're really, really likely, like that this did happen. However, I think none of this evidence, again, would seem to support the conclusion that jurists somehow controlled the texts of praetors' edicts. Okay, so at this point, as I was working through all of this, I began asking myself how actually might it have been possible that a view that seems to be founded on such weak evidentiary support could actually become so widespread that one can read it in every textbook of Roman law. And so while the scope of this paper here, of my presentation here, only allows for speculation on this front, really, I think the enterprise is nonetheless rewarding. I think for one, and as so often, Savigny, the historical school, and the preference for Juristenrecht seems to have played a role in at least two possibly contradictory ways. Members of the historical school, as is well known, did not like enactments of law, and judicial edicts could readily be seen as an example thereof. This circumstance, I think, might explain why actually I've been able to find very little sustained scholarship on these edicts, their history, and how they were composed. The most sustained engagements really stem from the United Kingdom and from Ireland, where the possible similarities and differences with the English system of writs seems to have generated at least some interest in the question. But I also think that beyond generating a lack of interest in judicial edicts, the historical school and its assumptions might also have worked to sustain the myth of jurist control of judicial edicts. If, as these scholars like to think, Roman law was indeed a system that jurists had developed, then jurists must have also overseen on some level the Praetorian edict. After all, right, this was such an important source of law, particularly private law in ancient Rome. Most importantly, though, I'm inclined to think that the myth of jurist control of the Praetorian edict was the tool for keeping Roman law familiar. It helped maintain the idea that ancient Rome, from the Republic onwards, already knew something and was committed to something and was familiar with something like the rule of law. Franz Wiecker recognized, right, in his arguments about why, really praetors never made use of this sort of programmatic potential of edicts. He sort of has all these fantasies, and one of them is that sort of these edicts hold the potential for what he called extravagante oder revolutionäre Experimentatoren in der Amtstoga, so extravagant and revolutionary experimenters wearing, the official toga of a Roman magistrate. Right? And so he recognizes this potential, and I think basically he recognizes the potential for a world, a Roman legal world, in which legal remedies and offers could be different each year, and a world in which a praetor could indeed, I think, enact the revolution, if he so chose. So above all else, I think the existing claims surrounding the edicts of the praetors and how they were composed seem to be designed to close the door on this possibility. Arguably, this impetus also allowed scholars to disregard important evidence for how such edicts were composed. And so, as I hope to show now in the remaining part of my paper, this evidence would seem to make a certain degree of otherness about these edicts, about Roman legal culture, difficult to deny. Roman magistrates, I contend, could and did involve themselves in composing the judicial edicts they issued, making changes and innovations as they saw fit. In so doing, they staked out claims for themselves in relation to important political questions of the day, often with far-reaching consequences, not just for litigants, but also for themselves. All right. So with this now, I turn to the second part of my presentation, where I'll discuss the evidence and try to think a bit about how edicts in the provinces were composed. Well, the Edict of the Praetor Urbanus tends to take center stage in discussions of judicial edicts in Rome. The members of Rome's office-holding elite that left the city every year to govern the regions around the Mediterranean over which Rome claimed to rule also issued such edicts. In fact, the best evidence for the composition of these texts stems from Rome's provinces. More particularly, it relates to the time that Cicero spent governing the province of Cilicia in southeastern Anatolia in 5150 BCE. And so as governor, Cicero wrote many letters to his friends in Rome and elsewhere. And while really we only have a fraction of these letters preserved, 4 of them do discuss judicial edicts, mainly Cicero's own, but also those of his predecessor in Cilicia and of his colleague in the province of Syria. 3 of these letters were addressed to Cicero's friend Atticus, the 4th to Appius Claudius, the previous governor of Cilicia. And you can find all these passages under, I think, 2A to 2D on your handout. And I'll sort of jump a bit between them, but I always try to make sure that I point out which passage it is that I'm referring to in my argument. Okay. Great. In these letters, we learn that Cicero saw himself as the author of his edict. I put it together in Rome, he writes in 2A on the handout, composui Romae. He also seems to have had some idea of the areas of law that his edict should cover. He divided his edict into several sections. One of them, he claimed, in the passage on 2b, contained all that cannot be conveniently transacted without an edict, followed by a list of subjects which included questions of inheritance as well as ownership and sale. These matters, Cicero wrote, were wont to be handled with recourse to the provisions of the edict, hence he had to include provisions pertaining to them. He reserved another section of his edict for questions that he expected to give rise to disputes in a provincial context. Among other things, they included debt, tax farmers, and civic accounts. Crucially, his letters also give us some clues about the origins of the concrete provisions that he included in each of these sections. For one, Cicero seems to have put his edict together by drawing on different past edicts. He does not appear to have blindly copied his predecessor's edict. In 2a, he recounts how the tax farmers of Cilicia asked him to take over a set of provisions from his predecessor's edict. At the very least, then, Cicero must have been selective in what he adopted from this edict and what he adopted from Appius Claudius' edict, if indeed he consulted it at all. In the same letter, Cicero also claimed in relation to one clause in his edict that it was tralaticium, that he had taken it over from another edict. And I think it's really crucial, like it's really interesting and relevant for my argument that this particular edict from which he claims to have taken it over cannot have been his predecessor's edict. Right? The context of the passage makes this reading impossible. Now, the clause might then have stemmed from one of the two edicts about which we know that Cicero consulted them. Those are probably, first one, we're not quite clear about the identity, but it seems likely, those of Licinius Crassus Mucianus, Pontifex Maximus, and governor of the province of Asia in 1310 BCE. And the second edict would be that of Quintius Mucius Scaevola, from when he was governor of that same province, the province of Asia, in the 90s BCE. So while still in Italy, Cicero had asked Atticus to send him a copy of the former, to send him a copy of the edict of Licinius. This is 2c on your handout, and in 2d on the handout, he then told Atticus about one particular clause, one particular exceptio that he adopted from the edict of Scaevola. So based on this evidence, it seems likely that Cicero, I think, displayed a marked preference for the edicts of governors that could claim some legal expertise. Right? Should be noted. Both Quintus Mucius Scaevola and Licinius Crassus Mucianus had been members of the Pontifical College, which had traditional authority over legal matters. Scaevola, of course, was also the man who was credited with separating out the jus civile as something that could be studied and expounded, expounded, and developed without pontifical authority. In addition, he was considered a model governor in the 1st century BCE. On one level, then, Cicero's composition of his edict marked by possibly a very high degree of conservatism, but this conservatism was selective. He consulted authoritative models, past models, and chose provisions from them as he saw fit. At the same time, Cicero also claimed that certain provisions in his edict were new. In fact, he prided himself on having introduced a set of new provisions concerning the expenses of local communities. And you can find this claim in 2a on your handout. While in this passage, Cicero makes no mention of consulting anyone with legal expertise, he does also not, strictly speaking, claim that he wrote the section in question personally. Right? He says, diligentissime scriptum est. The section has been written in the most careful manner. This phrasing might then allow room for the work what Lenik Steinthaler has called jurists in the shadows, right? Possibly the many men of relatively low social standing in Rome that must have had some form of legal expertise, experience, and skills. However this may be, Cicero wrote that he rejoiced in these innovations as a great achievement, magnus opus. Based on the context of the passage, I think, or I would be inclined to read him as saying that he basically considered them his own achievement, and that's also why he takes such pleasure in them. I mean, this is kind of the man one would imagine Cicero to be. Okay, now, Cicero also claimed that these provisions contributed to the financial health of local communities in Cilicia, an agenda that demonstrably marked his entire time as governor of the province. So you can find this theme in not all, but many, many letters that we have preserved that he wrote from Cilicia to Atticus. Overall, then, Cicero seems to have composed his edict by selectively drawing on authoritative edicts from the provincial legal past. by consulting with interested parties about the precise provisions that he might select, right? Think about, remember this meeting that he had with the Publicani, with the tax farmers on the island of Samos, where they said, oh, we would like these provisions included, and Cicero seems to have said, all right, let's do this. And then the third option, so the third factor is that he also formulated his own provisions in certain areas, provisions that he might have hoped would become, I think, models for others. In what follows, I will suggest that this combination of strategies was not limited to Cicero. These strategies, I think, resulted from the risks and rewards that composing judicial edicts offered in the context of Roman political culture. So to begin with, Cicero's consultation with Roman tax farmers in Cilicia does not appear to have been an exception. Interactions with and concern for interested and potentially affected parties appears to have been an important factor shaping how magistrates like Cicero composed their judicial edicts. The letter in which Cicero outlines his interactions with these tax farmers makes no mention of how they framed their requests. Most likely, though, I think, they invoked the bonds of reciprocity and patronage that connected Rome's political elite to other members of society. At the time, this seems to have been a widespread way of approaching Roman magistrates, not least in the provinces. And so I give you some reference to scholarship from the 80s, which sort of mentions this always in passing, but it's clearly there. And I would also point you to book 13 of Cicero's Ad Familiaris, where such approaches on the basis of patronage to governors are really well documented, especially in Cicero's own letters of recommendation, which are preserved there, which always aim to facilitate precisely such approaches. Crucially, Cicero himself invoked the obligations that reciprocal relations placed upon him when explaining his choice to include a certain provision in his edict. And so this is 2C on your handout, and there he points out to Atticus that the inclusion of a certain exceptio in his edict depended on this exceptio not hurting anyone who had done him a favor in the past. In composing his edict, Cicero thus anticipated how the clauses he included might affect people to whom he was obligated. His choices should not negatively affect them. In case of the tax farmers, the bonds of patronage might have led him to include a provision that obligated others to him, right? So him might have then thought, all right, so then I can expect something in return. Crucially, Appius Claudius, Cicero's predecessor, also seems to have known or seems to have assumed that personal relations might factor in how a magistrate composes his edict. His accusation that Cicero included certain provisions in his edict with the goal of hurting Claudius, or hurting him, or hurting Appius Claudius, appears to be predicated on precisely this assumption. So far then, I think we can conclude that Cicero, Claudius, and their contemporaries lived in a world in which personal relationships, both friendly and inimical, could, did, and were expected to shape the provisions that a magistrate like Cicero might include in his edict. So here then, I turn to my second point, which is that Cicero's selective conservatism very likely was not exceptional either. Arguably, such conservatism was a safe strategy in a world in which the old did not have to be defended and the new seems to have aroused suspicion. So when Appius Claudius accused Cicero of including a provision in his edict with the goal of hurting him, Cicero mounted what I think is a curious defense. Again, this is 2A on your handout. The provision in question, unlike others he had included, was not new. It was tralaticium. Cicero had adopted it from another edict. On one level, we can see how this argument might work, right? Cicero was claiming that he had not thought up something new and special just to hurt Claudius. At the same time, the argument, at least to me, does not appear to be fully conclusive sort of at first sight. Appealing to precedent does not appear to get to the core of Claudius' charge, right? The provisions in question might have featured in previous edicts, sure, but Cicero might also have chosen to include those precise provisions in his edict because he knew that they would hurt Claudius. Intriguingly, this letter is not the only occasion on which Cicero appealed to the not newness of certain edictal provisions to defend them against criticism. The second example stems from a letter to Atticus in which he discussed certain charges that his friend had leveled against a new exceptio in the edict of Bibulus, who was governor of Syria at the time. So this is 2D on your handout. According to Atticus, this exceptio was excessively severe in its attitude towards our order, most likely the equestrians, maybe the taxonomists, but I would think the equestrians. Okay. Cicero tried to allay Atticus's concern. Cicero himself, he claimed, had included a similar clause in his edict. It was simply more guardedly phrased and originally stemmed from Scaevola edict. Again, one might wonder what the not newness of a certain provision had to do with the way in which it affected a certain group of people. Furthermore, it is striking that Atticus and Cicero focused on the one aspect of Bibulus's edict that was supposedly new. Atticus seems to have worried that it might constitute a praejudicium against the equestrian order. And so this term can mean something like prejudgment or attitude, which is how I've sort of translated it so far, also on the so far in my talk. Much more frequently, though, actually, this term can be translated, can be thought of as precedent. And now, not in any sort of technical legal sense, but more broadly speaking. Arguably then, Atticus might not just have worried about Bibulus's attitude to the equestrian order, but also about the provision's potential for setting a precedent, about the possibility that once that clause had indeed featured in an edict, it would be much easier for subsequent parties, magistrates, and litigants alike to justify its inclusions in future edicts, right? Because just as Cicero said, look, it's praeticium, I don't really know what your problem is, right? I've just taken it over from another edict. Excellent. All right. So from this perspective, I think we can begin to understand how Cicero's suggestion that the provision in Bibulus's edict was essentially equivalent to one in his and Scavola's edict could work to allay Atticus's concern. Bibulus's exceptio, so Cicero suggested, did not introduce anything more injurious into the Roman legal reservoir, right, or into the Roman edictal reservoir than what this reservoir already contained. Most likely, I think Bibulus would have disagreed. Well, we do not know what he thought to achieve by introducing this differently formulated exceptio. It seems at least possible that he was out to leave his legal and political mark, just as Cicero has sought to do in relation to the expenses of local communities. In 5150 BCE, the Parthian threat loomed large in the Greek East and seems to have prompted various attempts at provincial reform to keep these regions of the empire loyal. In this context, provisions that limited the ways in which equestrians might exploit and displace local populations could readily be connected to such reform efforts. At the same time, the concerns of Atticus showed that such innovations not only promised rewards, they also came with distinct risks. As Atticus's analysis suggests, legal provisions could be treated as a political barometer, as a way of assessing where a man stood vis-a-vis the interests of important groups in Roman society. Then, of course, they would affect certain people negatively. After all, such provisions determined what would be just for 1 year and possibly beyond, and this, I think, was a great responsibility. And I think for these magistrates, for people like Bibulus, for people like Cicero, repeating provisions that had featured in previous edicts and thus were part of Rome's legal past arguably helped these magistrates to deflect and avoid this responsibility. Selectively choosing from a range of different edicts, as Cicero did, allowed them to do so while still being able to negotiate over provisions with potentially affected parties, especially those with whom the bonds of reciprocity and patronage connected them. And so now in the following section, I'll try to mobilize a very different set of evidence to suggest that judicial edicts in the city of Rome that we can think of them as being subject, or so that we can think of their composition as being subject to analogous dynamics. All right, so part 3, judicial edicts in the city of Rome. So to discuss the making of judicial edicts in the city of Rome, I return to what arguably is the most elaborate account of Roman judicial magistrates in action, Cicero's portrayal of Verus's actions praetor Urbanus in 74 BCE. As outlined at the very beginning of this paper, Cicero showed Verus composing his edict by organizing a marketplace in which the highest bidder had his or her way. As part of this project, as part of this sort of goal, Cicero focused on one provision in Verus's edict. Tellingly, this provision was new, or so Cicero claimed. It's again new, one can become suspicious, and it altered a part of inheritance law that had long featured in judicial edicts in Rome and in the provinces, a provision that virtually every judicial magistrate included, or so Cicero claimed. Cicero, of course, tried to convince his audience that Varus had been paid to make the change, right? But this does not appear to have been the only interpretation of Varus's administration of justice during his time as praetor urbanus, right? So one interpretation is, oh, it's bloody corrupt, and here goes the other one, because Cicero also recalled some jokes that contemporaries made about Varus at the time, and these jokes all turned on the relationship between Varus's cognomen, Varus, and the word for hog or boar. Right, and so one joke goes, the jus verenum, Hogg's law, was of course poor stuff. And Varus's predecessor, Sacerdos, or Mr. Priest, the priest, was blamed for having left behind a miserable hog, an animal that as priest he should have sacrificed. Crucially, these jokes, I think, do not relate, or on the face of it, at very first glance, they're not about Varus's supposed venality, his greed, or his corruption. Instead, they seem to have focused on what some contemporaries at least perceive to be the lack of fairness, the lack of equity, the lack of justice that inhered in his practices as praetor urbanus. And these jokes as such, right, they do not say anything in particular about why he might have been so unfair, unjust, unequitable. They just note it and make fun of it. The fact that the adjective nequam, which is a combination of ne and equus, meaning fair and equitable, recurs in both of these jokes, I think would suggest that that's really sort of the gist of it. So on some level, to me, these read like sort of almost like they read like lawyers' jokes or something, right? This sort of people claiming some sense of equity, fairness, and justice and skill, expertise in these areas, saying, "Oh my God, he really counted it," and that's the joke. Okay. Cicero already says these are not very good jokes. I think he's right, but there you have them. Okay. There were then, I think, at least two different critiques of Varus's actions as urban praetor. Cicero focused on his supposed corruption, as fitted the context of his speech. The jokes from the time of Varus's actual praetorship seem to have focused on his lacking sense of justice, fairness, and equity. One might then also at least posit the possibility that Varus, like Cicero and Bibulus, decided to introduce a new provision in his edict as part of his political aspirations. If this was indeed so, it's very clear that his plan did not work out. Regardless of how they were motivated, his actions and how Varus's actions and how Cicero portrayed them do show that also in the city of Rome, the provisions of judicial edicts could and did vary from year to year. Right? After all, Cicero did not argue that Varus's behavior deviated from the norm because he was the only praetor urbanus to have ever replaced an existing provision with another one. Instead, his point turned on Varus's motivations for making these introductions. The fact that contemporaries seem to have read judicial edicts in Rome quite eagerly would further support this line of argument. And so to illustrate, the Augustan jurist Labeo imagined the plaintiff and a defendant standing in front of the edict, or rather the album, as he called it, with the former pointing out the action that he was intending to use. According to Labeo, this was a way in which plaintiffs could be said to have given notice to defendants. About 50 years later, the politician and philosopher Seneca claimed that if somebody was running after a midwife for his daughter, he would not stop to read the edictum or the annual schedule of games. The singular edictum and its pairing with the schedule of games make it likely that Seneca was indeed thinking of the judicial edict of the praetor urbanus in Rome here. As such, the passage would seem to suggest that under different circumstances, right, when no emergency bore down on them, that is, people might well read these forms of temporary public writing. The parallel between judicial edicts and the schedule of games, to me, also is interesting. In both cases, right, contemporaries might have had a rough idea of what to expect. Oh, yes, there'll be some gladiators, and there'll be some lions, and oh, yes, there'll be some about sail and some about ownership. The concrete details, however, could and might indeed vary from year to year. In the case of judicial edicts, such variations could have wide-ranging consequences, and the different preserved versions of the Interdictum de Via Marta illustrates this variation and its consequences most vividly. Good. So, broadly speaking, as many of you know, the Interdictum de Via Marta outlined one condition under which the magistrates in question promised to protect possession even after it had been lost. If the loss of possession had resulted from the use of armed force, or vis amata. In two speeches of Cicero's, we have two different versions of this interdict preserved. One seems to have been part of the edict of the urban praetor in 73-2 BCE. The other featured in the edict in 69-8 BCE. In the earlier version, the concept of dolus malus played a central part in the interdict. Claimants seeking to regain possession had to show that they had lost possession not just through force, but through the dolus malus of the new possessor. In other words, they would most likely have had to provide some evidence of his or her, of the new possessor's mental state. In the second version of the interdict, such evidence was no longer required. In 69-8 BCE, simple evidence of the use of violence by the new possessor or a member of his household were enough. We do not know what moved the praetors of 73-2 and 69-8 to include these rather different provisions in their edicts. Whatever the motivations, though, it should be clear that in these 2 years, rather different kinds of claimants had a chance of winning their case. In 73-2 BCE, it might have been possible to gain possession of an estate by force and keep it so long as you could convincingly show that you were somehow under the impression that the property in question was yours. And in 69-8 BCE, that, I think, was no longer an option. So the most compelling argument in favor of the idea that the Edict of the Praetor Urbanus was a stable text relies on the fact that by the second half of the 1st century BCE, men, jurists like Servius Sulpicius Rufus and Aulus Ophelius wrote commentaries, or are known purported to have written commentaries on this edict. As has been pointed out, however, we know close to nothing about the actual shape of these commentaries. Furthermore, Cicero's account of his own edict would suggest that there was a widespread consensus about the areas of law that judicial edicts were to cover, while the actual provisions in question were not really set in stone. One might readily imagine how commentaries about the edict also in the city of Rome were structured around such areas that kind of, right, there was like custom, people agreed, yes, litigants will approach the praetor in these areas, so they need to be covered, that these commentaries then explicated concepts and terms that were often invoked in these areas, and possibly that they also took positions on actually the precise provision that should be included. Overall, I would suggest, though, that various legal innovations, the fact that contemporaries studied the text of the praetors that the praetors had painted in red and black on white wooden boards, as well as the attested variations in the Interdictum de Via Marta, all make it rather likely that also the provisions of judicial edicts in the city of Rome could and did vary from year to year with profound and meaningful consequences for potential litigants. Consequently, we might also imagine that just like in the provinces, these litigants tried to influence the magistrates in question as they were composing their respective edicts. Episodes surrounding debt revolt in the city of Rome would appear to provide evidence of litigants attempting to do just that. And so it's these debt revolts to which I now turn. During the 80s BCE, the city of Rome experienced a set of severe debt crises, most likely because of the social war and the Mithridatic revolt in the Greek East. We know about these crises through the concentration of political measures taken in relation to debt and credit during this decade. The Praetor Urbanus in 89 BCE, Aulus Sempronius Asellio, is the first person on record to take such measures. Appian provides the most detailed account of his actions. In short, Asellio instituted trials in favor of debtors, a decision for which the creditors ultimately killed him in the forum. On Appian's telling, Asellio's action were a response to the arguments of debtors who invoked an ancient statute that outlawed lending at interest. Indeed, we know of one such law, the Lex Finucia of 342 BCE, and Cato the Censor and other members of Rome's political elite in the 2nd century BCE were also known to have taken measures against lending at interest. Whatever the precise law to which the debtors appealed, they seem to have used the authority of a statute of Lex Publica to shape Asellio's judicial program. We do not know the precise nature of the provisions that Asellio then eventually issued. And it's very interesting, I think, to note that Appian writes that Asellio was trying to place the burden of the decision, or indeed, as Appian phrased it, the impasse, the aporia of law and custom onto the judges. Maybe then, Asellio here was trying to kind of engineer these trials in such a way that he would avoid personal responsibility to whatever, for whatever happened in them. The creditors, of course, did end up holding him responsible. Asellio was reviving the old law, so Appian wrote, and so the debtors had probably claimed, and they killed him for it. Marcus Gratidianus, another praetor urbanus in the 80s BCE, appears to have been luckier. He published an addition to his edict during his term of office. While the nature of the measure is widely debated, it seems clear that it has something to do with the value of money and thus with the payment of debts and rents. As a result of this measure, images of Gratidianus started to appear in the Vici, in the neighborhoods of the city of Rome, and people poured wine and burned incense in front of them. In other words, a veritable Gratidianus cult arose all throughout the city of Rome, and all because of an edict with judicial ramifications. Considering these two episodes from the 80s BCE, it should not come as a surprise that 20 years later, in the context of yet another debt revolt in Rome, the debtors not only complained that their creditors were oppressing them. Instead, they saw both their creditors, the moneylenders, and the praetor urbanus as the cause of their suffering. As Sallust recounted, the debtors in the context of the Catilinarian conspiracy also appeared to some statute, some lex that could offer them the protection that the injustice of the praetor, so they claimed, had taken from them. Now, to be sure, these narratives about debt crises do not show urban praetors composing the edicts, right? However, I think they can be made to speak to the assumptions with which litigants approach such edicts and the magistrates that issued them. And these assumptions, I would suggest, are strikingly similar to the logics that I've argued underpin Cicero's composition of his edict in Cilicia. So 1, the debtors in the narratives of Appian and Sallust thought that the legal provisions in the praetors' edicts were up for grabs. And they assumed that they, as potentially affected parties, might have a chance at influencing these provisions. In so doing, they seem to have held the same beliefs that the Roman tax farmers in Cilicia, who approached Cicero on the island of Samos before he entered his province and then also on that occasion proclaimed his edict, to sort of get some provisions in that we just assume would be favorable to them. Okay. Second, the debtors in the narratives of Appian and Sallust also understood, I think, that appealing to the legal past, suggesting that all they really wanted was a rule to be enforced that had already been upheld once, would help them convince the praetor to acquiesce in their demands. Again, one might point to the tax farmers and their request that Cicero adopt some of his predecessors' provisions. Being able to claim that they were only reiterating legal provisions already in existence allowed judicial magistrates to deflect personal responsibility, I think. In Asellius' case, that strategy clearly failed. In others, less fraught situations, like the one involving Bibulus's exceptio, such argument might indeed have helped to shut down discussion. Lastly, the creditors that killed Asellio also seem to have understood the dynamics of innovation in edictal provisions. While the debtors might have appealed to old statutes as a source of their protection, the creditors most likely understood that at the level of edictal provisions, the debtors were indeed asking for an innovation, a new addition to the reservoir of such provisions that were continuously accumulating in Rome. Like Atticus, I think, they might have worried about a praejudicium, a precedent against their order. So, both in the provinces and in the city of Rome then, composing a judicial edict appears to have been a delicate balancing act. And both in the provinces and in Rome, I would suggest it was Roman magistrates that were doing a large part, or that, were doing this balancing, not least because in the end, they were held responsible for it. Wherever they went, Roman magistrates were involved in the composition of the judicial edicts that they issued. Unlike what Vieta imagined, however, this circumstance did not make them extravagant or revolutionary experimenters. Instead, these judicial edicts seem to have been a part and parcel of how members of Rome's political elite built their careers. Edicts allowed these men to make a name for themselves. They provided a way for them to further develop the patronage networks in which they were enmeshed, and they gave these men a means by which to position themselves in relation to the social, political, and economic questions of their day. As a result of these dynamics, judicial edicts in Rome, I think, were plural. They were potentially different each year, and they distinctly belonged to the magistrates that issued them. They were, as I've tried to argue, the edicts of the praetors and not the praetorian edict. As such, judicial edicts were an integral part of Roman politics and political culture. When this politics turned revolutionaries, right? When debtors called for the abolishment and for the cancellation of their debts, Roman judicial magistrates had difficult and consequential choices to make, because as I hope to have shown, at least made possible, the way of doing law that their edicts enshrined was indeed able to encompass and enact revolution, at least for a year. All right, thank you very much. Now, as I said, I look forward to your comments and to the discussion. Thanks.